Welcome to our TV show featuring documentaries revealing the realities behind myths using research and scholarship. I'm your host, Ergün Kırlıkovalı, and I will be with you every Sunday at 6 p.m. Eastern Standard Time. You're welcome to send me your feedback at #ethocide. Repeat, #ethocide. The highest court in Europe, the European Court of Human Rights, or ECHR for short, issued a milestone of a verdict on October 15, 2015, that will resonate for decades to come. The ECHR Grand Chamber ruled that Armenian genocide is an opinion, not a court verdict. As such, it can be rejected, and that would be an exercise of the human right to freedom of speech. Thus, it was determined by the highest court in Europe that refuting and rejecting and disproving the alleged Armenian genocide was not a hate speech, as the deceptive Armenian lobby likes to claim, but it was mere free speech. Furthermore, the court ruled that the alleged Armenian genocide could not be compared to the court-proven Jewish Holocaust. The latter had gone through legal scrutiny at a competent tribunal, and the intent to destroy was documented to be factual. Please see the Nuremberg verdict of October 1st, 1946. Armenians never had a Nuremberg. They never tried to bring this issue to a competent court because they know their case would collapse in the first court session, just as soon as the other side of the story unfolds. Turks would effortlessly show the court that Armenians took up arms against their own government, incited many armed and bloody rebellions since 1862, aided and abetted the invading enemy armies, engaged in systematic intimidation and terrorism, deliberately and consistently exercised supreme treason, made arbitrary, baseless, and arrogant territorial claims in lands where they were only a minority, massacred hundreds of thousands of their fellow Turkish and Muslim Ottoman citizens, and misrepresented a temporary resettlement program, or TERESET for short, triggered by the threat those Armenian fifth column activities posed to the Ottoman war effort as genocide to the unsuspecting world community. The journey that ended with the landmark decision by ECHR's Grand Chamber began with a simple step in 2005. Dr. Doğu Perinçek, a legal scholar and a politician of Turkish nationality, traveled to Switzerland to challenge the Swiss denial law, whose protection was illegally stretched to include long discredited political claim of Armenian genocide. That law was meant to prevent denial of proven genocides that have court verdicts backing them, such as Nuremberg, Rwanda, and Srebrenica. The long discredited political claim of Armenian genocide was not backed by any court verdict and did not qualify for protection under this law. Dr. Perinçek made 3 separate public statements in 2005 that the use of the word genocide to describe the fate of Ottoman Armenians in the First World War was an international lie. After the first statement, the Switzerland-Armenia Association filed a criminal complaint against Dr. Doğu Perinçek for his public denial of the alleged Armenian genocide. In March 9, 2007, the Lausanne District Police Court of Switzerland found Dr. Perinček guilty of violating Article 261 bis 4 of Swiss Criminal Code. Dr. Perinček was fined 3,000 francs or 30 days in prison and ordered to pay 1,000 francs to the Switzerland Armenian Association for intangible damages. Perinček's appeal was dismissed by the Vaud Cantonal Court on June 13, 2007, and dismissed by the Federal Court on December 12, 2007. Having exhausted internal legal means in Switzerland to redress his grievances, Dr. Perinček he appealed to the ECHR on June 10, 2008. He said that the Swiss courts had wrongfully breached his right to freedom of expression under Article 10 of the European Convention on Human Rights by convicting him for denial of the alleged Armenian genocide. Under Article 10 of the Convention, everyone has the right to receive and impart information and ideas without interference by public authority. The wheels of justice turned very slowly. 4.5 years later, on December 17, 2013, a chamber of the ECHR found by a 5-2 majority that Dr. Perinček's rights had been violated under Article 10 of the European Convention on Human Rights, which deals with the right to freedom of expression. The chamber concluded that the reasons given by the domestic court of Switzerland were insufficient to justify this conviction. In particular, it held that in light of all the circumstances, the conviction neither amounted to a pressing social need nor necessary in a democratic society. The court verdict reminded that allowing expression of opinions on a controversial issue is a fundamental aspect of freedom of expression, which separates a pluralist, open-minded, and democratic society from totalitarian regimes. The court also looked at whether other states criminalized the denial of historical events and found two groups of countries. In Group 1, you have Austria, Belgium, France, Germany, Netherlands, and Romania. They criminalized only the denial of the Holocaust and the Nazi crimes. In Group 2, you had Hungary, Latvia, Lithuania, Macedonia, Malta, Slovakia, Slovenia, and Switzerland criminalized the denial of any genocide. One must surely separate a claim from a fact, ethnicide from genocide, before 1948 UN Convention or after. What is clearly lacking here is the qualifier court-determined genocide. The court found that Switzerland stood at the end of the spectrum, as it criminalized the denial of any genocide without the requirement that it be carried out in a manner likely to incite to violence or hatred. The court held that Perinček's criminal conviction was severe, particularly when other means of sanction could be imposed by the Swiss government. Notably, the ECHR stated in paragraph 117 this: "It is even doubtful that there could be a general consensus, in particular a scientific one, on events such as those that are in question here, given that historical research is by definition open to debate and discussion and hardly lends itself to definitive conclusions and objective and absolute truths. Perhaps even more substantively, the ECHR underlined in paragraph 118 this: genocide is a well-defined legal concept. For the violation to be described as genocide, it is necessary that the actions committed be accomplished with the intention of destroying in whole or in part the group as such. Dolus specialis, intent to destroy, is a very strict legal concept, which is difficult to prove. The court is not convinced that the general consensus to which the Swiss courts have referred to justify the conviction of the applicant can bear on these very specific points of law. In line with this perspective, against the attempts of Switzerland to draw parallel between the Jewish Holocaust and the 1915 events, the ECHR argued in paragraph 120 that the Armenian case was, quote, clearly distinct from cases bearing on denial of the Holocaust crimes, unquote, because Holocaust was an established fact both through historical research and international courts. Taking into account all of the above-mentioned factors, the court concluded that Swiss government's interference with Perinček's right to freedom of expression was not necessary in a democratic society. As a result, it found the government in violation of Article 10 of the Convention. The Swiss government, unhappy with this embarrassing verdict and under pressure by its irritating and noisy Armenian lobby, requested that the case be referred to Grand Chamber on March 17, 2014. This is very strange because the same Swiss government had earlier promised the Turkish government not to pursue this matter any further. So much for trusting Switzerland. Reneging on a promise at the last minute, Switzerland hurt its credibility and neutrality in its relations with Turkey and perhaps with other countries. The Grand Chamber delivered its judgment on October 15, 2015, by a majority of 10-7 judges and upheld the decision of the lower court that Perinček's right to freedom of speech had been violated. It said it had to strike a balance between two convention rights, the right to freedom of speech, Article 10, and the right to respect for private life, Article 8. It found that Perinček's statements bore on a matter of public interest and did not amount to a call for hatred or intolerance. They could not be regarded as affecting the dignity of the members of the Armenian community. It was not necessary in a democratic society to subject Mr. Perinček to a criminal penalty in order to protect the rights of the Armenian community. There was no international law obligation for Switzerland to criminalize such statements. The Swiss courts appear to have censured Mr. Perinček simply for voicing an opinion that diverged from the established ones in Switzerland. The very fact that Mr. Perinček had been criminally convicted was significant in that it was one of the most serious forms of interference with the right of free expression. In the opinion of dissenting judges, that the massacres and deportations suffered by the Armenian people constituted genocide is self-evident. It is certainly not obvious to Mr. Perinček and millions like him, including distinguished Ottoman historians, who believe the claim is a subjective reading of history. This was a victory for the freedom of expression. It was certainly not a victory for Armenian lawyers or government, as their goal was not to hear the ECHR Grand Chamber uphold the earlier decision in favor of Dr. Perinček. The majority of judges avoided judging the events of 1915 and restricted themselves to upholding the right of an individual to disagree with a mainstream view. The court criticized the Swiss courts for punishing Dr. Perinček for it. Parliaments with little or no knowledge of the Ottoman history have passed genocide resolutions, although there are no verdicts obtained from competent tribunals after due process. If they knew that Armenians were the perpetrators of large-scale violence throughout the war, as well as its victims, they would not attempt to legislate history scholarship. There is no denial of the genocide, as it is only a claim, and by its nature, a claim cannot be denied, only challenged, refuted, discredited. The word denial has been used deliberately to stifle debate and keep a counter-narrative out of the minds of unsuspecting truth seekers. This heinous tactic has been effective, as most editors today will not publish responsible opposing views for fear of being associated with denialists, while they will happily print even the wildest Armenian claims. The back-to-back 2013 and 2015 landmark ECHR verdicts dealt huge blows to this kind of auto-censoring and may finally make the editors more courageous to speak and seek the truth. This is not only a catastrophic failure for the Swiss diplomacy, which has violated its own centuries-long principle of neutrality, but also for those who tried to impose censorship on scholarly debate of a controversial issue. ECHR devastated the Armenian narrative with its final verdict by saying Armenian claim of genocide is an opinion, not a court verdict. As such, they can be rejected. That opinion can be rejected. And doing so would be an act of freedom of speech under the protection of Article 10 of the European Convention of Human Rights. In paragraph 156, the Grand Chamber explained eloquently why disagreeing with Armenians do not deprive Armenians of their self-respect. It can hardly be said that by disputing the legal qualification of the events, the applicant cast the victims in a negative light, deprived them of their dignity or diminished their humanity, the court said. And in paragraph 231, the court states that Perinček took part in a long-standing controversy that the court has described as heated debate in the international arena. By definition, if there's a heated debate in the international arena, none of the interpretations presented can be regarded as backed by a general consensus. My note here, so the next time you hear the pro-genocide groups talk about general consensus, kindly remind them of the ECHR's 2015 verdict, paragraph 231. International law rejects the Armenian argument. Now, back to the ECHR verdict. In paragraph 287, the court states that it is possible in a democratic society to express opinions that diverge from those of the authorities and or any sector of the population. Implying censoring of opinions because they are not in line with governments or pressure groups is totalitarian. The court ruled that by its criminal conviction of Dr. Perinček for publicly expressing his views on Swiss soil regarding the Turkish-Armenian conflict, Switzerland breached Dr. Perinček's right to free speech. The ruling is nothing less than a spectacular legal victory for Dr. Perinček Turkey, and Turks around the world, and a game changer. Now that the initial feedback and reflexive reactions are over, perhaps we can take a more composed look at this milestone of a legal verdict. The verdict has its 300 paragraphs, conclusions, and dissenting opinions, each of which could easily inspire a long article, even a book. I shall confine my analysis, therefore, to the press release issued by the registrar of the court, marked ECHR 325, 2015, and dated 15th of October 2015, which is an excellent summation of the verdict. For easier comprehension, I numbered the various aspects to consider. I also took the liberty, for your enjoyment, to grade each finding as pro or con for the Armenians and Turks. 1, it is final. There are no more appeals or higher courts. This is it. Grand Chamber judgments are final. All final judgments are transmitted to the Committee of Ministers of the Council of Europe for supervision of their execution. Good for Turks. 2, the Grand Chamber of ECHR agrees with lower court's 2015 verdict, and this is the law of the land now. As we would like to say in America, there's a new sheriff in town now, and he says disputing an opinion such as the Armenian allegations of genocide is an exercise of freedom of speech, which right is protected under Article 10 of the European Convention on Human Rights. Good for Turks. It fine-tunes the denial laws and teaches Switzerland and the rest of the world that only genocide supported by verdict of a competent court shall benefit from the protection afforded by the denial laws. So while the Jewish Holocaust, Rwanda, and Srebrenica are protected because they are court-proven genocides, the Armenian claim of genocide is not protected because it remains an opinion. Disputing an opinion is not hate speech, as Armenian lobbyists insist. It is an exercise in freedom of speech. Good for Turks. 4, ECHR verdict checks 100 years of Armenian arrogance, deception, and lawlessness, all masquerading as sole and blameless victims of a complex and tragic conflict dubbed genocide in mid-60s. That is, 50 years after the event. It's an afterthought, purely for political reasons. In case you missed, the verdict also makes the way forward crystal clear. Civilized dialogue based on facts, honesty and fairness, not fiction, deception, and bias. Good for Turks. 5, now we will be able to hear the other side of the story and get a fuller understanding of that complex tragedy. We will be able to grieve for all human suffering without dividing the victims into camps based on their faith, ethnicity, race, language, or nationality. No more selective morality, leaving out the archives showing Armenian complicity and guilt. No more stereotyping, intimidating, silencing, and censoring, and terrorism. No more one-sided editorials in New York Times, Boston Globe, Los Angeles Times, Washington Post, and other big media, or passing political resolutions dictating a certain view on history in defiance of critical thinking and facts. No more glut of one-sided academic books ignoring half the story. Will this be turning point for Turkish-Armenian relations? What are the future trends? Well, those are great topics for future discussions. Thank you for joining me. See you next week.